Welcome to the 2023 Anti-Doping Legislation webinar. My name is Yalixa Gonzalez. I am the coordinator of the Compliance Unit, Compliance Rules and Standards Department at WADA. The presenters today are my colleagues, Jonathan Jenkins, Senior Manager, Louis Duparc-Portier, Manager, Emiliano Simonelli, Associate Director, and with us today also a special guest, Dr. Diego Grippo, President of the National Anti-Doping Agency of Argentina. So for today's webinar, your cameras and micros are off. We have allocated some time for a Q&A session at the end of the presentation. You can send your questions two ways, through the chat in Teams, just by clicking the chat icon on top of the screen, and also by email to compliance. We might not be able to answer all your questions today due to time constraints. However, we will be happy to answer them by email. The webinar is being recorded and will be made public in YouTube. So without further ado, I'll leave the floor to Jonathan Jenkins. Thank you and enjoy it. Jonathan, the floor is yours.
Thank you very much, Yalixa, for that introduction. I'll just pull up the presentation. Just confirm that you see the screen.
Yes, we do.
Perfect. So yes, thank you very much for attending this webinar on anti-doping legislation, Keys to Success. My name is Jonathan Jenkins, and I'm a Senior Manager in the Compliance Unit at WADA. So first, I just wanted to lay out sort of the rationale for this presentation. So recently, we have noticed an increase in the drafting and adoption of anti-doping legislation. And we want to ensure that there is enhanced dialogue and collaboration with signatories and government stakeholders to ensure that their legal framework in a given jurisdiction or country is compliant with the World Anti-Doping Code and international standards. We also want to avoid the adoption of non-compliant legislation, which may result in a declaration of non-compliance and may also entail serious consequences for sport in a signatory's country. We also want to take the opportunity to further emphasize and better communicate the principles of operational independence as it relates to the activities and decisions of a national anti-doping organization. This is also an opportunity for us to discuss with you best practices as well as practices to avoid if you are thinking about drafting or adopting anti-doping related legislation. So when we talk about the regulatory frameworks or legal frameworks relating to anti-doping, it's very important to understand that there is no one size fits all for the effective implementation of anti-doping rules and anti-doping framework in a given jurisdiction. Indeed, it may not be necessary to adopt level 1 legal instruments, such as a law or an act, level 2 instruments, legal instruments, such as subsidiary regulations or ministerial decrees, in order to ensure the effective implementation and application of anti-doping rules in your country. The key is to determine and to ensure that a legal mechanism is in place so that the anti-doping rules are fully applicable to all national federations and their members. Indeed, if this can be effectively done without requiring the promulgation or adoption of a public level 1 or level 2 legal instrument, then this is what WADA recommends. It's also important to understand that by virtue of the legal doctrine of the hierarchy of norms, it is essential that any publicly adopted legal instrument is in compliance with the World Anti-Doping Code and international standards. Otherwise, non-compliant provisions will take precedence over compliant provisions which may be housed in a lower legal instrument, such as anti-doping rules. So when we're actually looking, yeah, here we go. When we're actually looking at the different framework within which we do our work, when we talk about sports law or anti-doping law, that's within the framework of the code. Generally speaking, general sports law may house certain provisions which are directly related to anti-doping and the different provisions in the code and international standards. This will obviously be the case if a country decides to adopt anti-doping specific legislation. This noted, other types of laws such as criminal law, law on administrative offenses, laws which prohibit illicit trade of prohibited substances and methods. Usually, these will fall outside the framework of the code, and we won't review such laws unless there's a clear discrepancy between the provisions therein and the provisions in the World Anti-Doping Code and international standards. So as mentioned, it isn't always necessary for anti-doping legislation to be adopted in a given jurisdiction in order for that country to have a compliant and applicable anti-doping framework and system. For those, however, who are looking to adopt anti-doping legislation, it's important to understand both the pros and cons of such adoption. Let's start with the pros. Well, first and foremost, it shows a solid commitment from the government, both from a political and financial point of view, to promoting clean sport and supporting a country's anti-doping framework. It will also provide legal certainty to all as it relates to the macro structure of a country's anti-doping framework and system. Third, it will also help to recognize and reinforce the NATO as the sole entity which implements the anti-doping program in your country and enforces anti-doping in your country. However, there are also cons which are related to the adoption of anti-doping related legislation. First, it's obvious that there may be a lengthy and protracted adoption and amendment process, which may in turn lead to certain risks when the code and international standards change. In this respect, it's important to recognize and understand that the code and international standards are living documents, which means that they're subject to periodic review. Thus, there may in turn be a risk when the code and international standards change, as if the legislation or legal instrument housing certain requirements or dispositions or provisions, if they aren't concomitantly changed, there's a risk that the NATO may become non-compliant. Now, speaking of anti-doping rules, as previously explained, while the adoption of anti-doping legislation, such as laws or regulations, isn't mandatory, Article 20.5.2 of the World Anti-Doping Code stipulates that national anti-doping organizations must adopt and implement anti-doping rules and policies which conform with the code and international standards. In many instances, these rules are adopted by the National Anti-Doping Organization, and the process for their adoption is more straightforward than would be the case for anti-doping related legislation or legal instruments. Usually, these rules will cover the full scope of mandatory and optional provisions which are required to implement the World Anti-Doping Code and international standards in a given country. Consequently, given the presence of such detailed procedural as well as substantive provisions in the anti-doping rules, there isn't a requirement, and this is a key point, there isn't a requirement for such provisions to be duplicated elsewhere, for example, in a law, a ministerial decree, or regulation. In fact, as will be later discussed by my colleague Louis, there are real tangible compliance risks with doing as such. Furthermore, it's important to emphasize, we'd like to emphasize that WADA has issued model rules, and these are template rules which help anti-doping organizations adopt and implement rules in their own country. Usually these will cover various mandatory and optional provisions. We have developed these in the past, and we will continue to develop these in the future. At this moment, I would like to pass the floor on to my colleague Louis, who will further discuss some of the key aspects relating to anti-doping legislation. Please, Louis.
Thank you very much, Jonathan, and hello, everyone. My name is Louis Duparc-Portier, and I am a manager in the compliance unit at WADA. So following Jonathan's initial analysis of the questions you should ask yourselves before embarking on the road of developing and adopting legislation on anti-doping, we will now focus on what you should think about in terms of the content of such a law. And the first message that we wish to convey, and that you can see on this slide, is that there is no one-size-fits-all approach when it comes to anti-doping legislation. The reason why there is no one-size-fits-all is due to the fact that the sport and anti-doping landscape, as well as the legal framework and traditions, are different and unique to each country. The exact content of an anti-doping law in one country will therefore be tailored to that country's specific needs. This is why WADA does not promote or recommend a model anti-doping law that NADOs could use for their respective countries, unlike the model anti-doping rules, which Jonathan spoke about in the previous slide. That being said, while there is no one-size-fits-all, there are some best practices and practices to avoid, which we strongly recommend that you take into consideration when drafting an anti-doping legislation. So let's first look at best practices when drafting an anti-doping law. First, you should use the law to reinforce the authority of your NADO to implement a comprehensive anti-doping program at the national level in your country. Second, include a provision on the automatic jurisdiction of your NADO over national federations, athletes, athlete support personnel, and all other persons involved in sport or doping control in your country. Third, your anti-doping law should make it clear that the NADO of your country is responsible for adopting anti-doping rules, which shall be automatically binding on national federations, athletes, athlete support personnel, and all other persons involved in sport or doping control in your country. By doing so, you are creating a legal mechanism under your legal framework, which ensures that your anti-doping rules are fully enforceable. Fourth, it is crucial that the anti-doping law is clear with regard to your NADO's operational independence from sport and government. This point is particularly important, and we will discuss it in further detail in the next slide. Fifth, we strongly encourage you to insert a provision on the obligation of your government to finance your NADO's activities. An issue facing some NADOs in practice is the difficulty to secure funding from the government. So including such a legal requirement in the law will provide a solid legal basis to guarantee that the government provides sufficient funds to your NADO, which are necessary for your NADO to carry its core activities. Finally, if your overall legal framework, particularly your laws on data protection, don't already provide the legal grounds on which your NADO could base itself to process personal information for anti-doping purposes, then we encourage you to include such a provision in your anti-doping law. The reason being that the processing of personal information in the context of a NADO's work is necessary, and it is important to ensure that your NADO can rely on a clear legal ground for the processing of personal information. A couple of examples of the legal grounds that could be used for processing personal information in the context of doping could include, among others, public interest or public health. Let us now discuss in a little bit more detail the requirement of operational independence of NADOs, which I mentioned in the previous slide. This requirement derives from Code Article 20.5.1, which you can visualize on the right-hand side of this slide, and is considered a cornerstone of the fight against doping. To give you a bit of context, NADOs can be considered the gatekeepers of the fight against doping in sport at national level, and public trust, as well as athletes' trust in these organizations, very much depends on their capacity to carry out their anti-doping activities free from any actual or potential undue influence from sport entities and governments. This being said, what do we mean exactly by a NADO being independent in its operational decisions and activities from sport and government? When we speak of operational decisions and activities, we are talking about a NADO's ability to take decisions and carry out the day-to-day activities of its anti-doping program, such as its testing or results management activities, without the influence or interference of persons who are involved in the management or operations of one of the sports entities listed in Code Article 20.5.1 or the government. Coming back to anti-doping legislation, it is therefore fundamental that any provisions contained in such legislation relating to NADO's activities and operations fully respects this requirement of NADO operational independence. For more information on this topic, we invite you to consult the WADA Guide on Operational Independence of NADOs, which provides a detailed assessment of what the requirement of NADO operational independence entails exactly. Now let's move on to some other worthwhile aspects which could be covered in your anti-doping legislation. Firstly, you could include the setup of your NADO's governing structure. For instance, a NADO's governing structure could include, on one hand, an oversight body which is not involved in the operational activities of your NADO, but which oversees the work of your NADO. And on the other hand, you will have a head of the operational activities of your NADO, such as a director general or a president, who would be responsible for the implementation of the NADO's operational activities and decision-making. You could also consider detailing the roles and responsibilities of your NADO, making sure that the operational activities and decision-making are compliant with the NADO operational independence requirement. You may want to consider including a provision on the NADO's accountability vis-à-vis the public authorities, such as the Ministry of Sports, as well as the NADO's own oversight body, by making it a requirement for the NADO to provide periodic reports on the NADO's activities or its multi-annual strategic plan to these public authorities or the oversight body of the NADO. And finally, you could include a provision on cooperation and sharing relevant information between the NADO and public authorities such as law enforcement or customs. This may be very valuable in terms of sharing intelligence, which could help both the public authorities' work as well as your own NADO's investigations into potential anti-doping rule violations. We have looked at the best practices when it comes to drafting anti-doping legislation. Let's now look at some practices which we strongly encourage you to avoid. As the first point, and I think it is difficult to miss on this slide, WADA strongly discourages you to include provisions in your anti-doping law which are already present in your NADO's anti-doping rules. If your existing legal framework or the anti-doping law you are planning to adopt already recognize the applicability of your NADO's anti-doping rules to national federations, athletes, athlete personnel, and other persons involved in sports or doping control in your country, there is no need to duplicate these provisions in the anti-doping law as well. Some of these provisions are mentioned on this slide and typically include the definition of doping, what are considered anti-doping rule violations, the consequences applicable to anti-doping rule violation, etc. Also avoid procedural provisions which are neither found in the NADO, or which are either found in the NADO's anti-doping rules, or which could otherwise be included in internal regulations of your NADO. We are talking here, for example, about the internal structure and functioning of your NADO, such as its different departments and committees. These should be dealt with separately in either the NADO anti-doping rules or internal regulations, as this will also give you more flexibility to amend them in case you realize that changes to the internal structure and functioning of your NADO or its committees are needed. Some further practices to avoid include provisions criminalizing conduct relating to anti-doping in your anti-doping law. WADA considers that this should be treated separately in the relevant criminal legislation of your country. Avoid having a legal framework pertaining to anti-doping, which includes multiple legal instruments of different legal value adopted by different authorities. In other words, go for simplicity. Otherwise, it will be difficult to understand the overall legal framework applicable to anti-doping, which will make things particularly complicated when you need to amend it, especially if the provisions of these legal instruments reproduce requirements of the code and international standards, which are subject to periodic reforms. Finally, avoid expanding the scope of activities of your NADO beyond its core responsibilities under the code and international standards. The reason for this is that NADO's resources are already limited, and we want to ensure that NADOs can focus their human and financial resources entirely on their anti-doping program. An example of what could be considered an activity that goes beyond the requirements of the code and international standards that we have come across is the responsibility for a NADO to label nutritional supplements as being free of prohibited substances. Avoid giving your NADO such responsibilities, which will overburden its already important mandate under the code. On this note, I will give the floor back to Jonathan, who will talk about the role of WADA in terms of compliance with a specific focus on legislation.
Thank you, Louis. So when we're talking about WADA's compliance role, WADA is responsible for monitoring and enforcing compliance with the code and international standards. And this normally starts with the review of key documents, including rules, regulations, and legislation. When implementing the compliance framework and enforcing compliance requirements, WADA is guided by the International Standard for Code Compliance by signatories. And the adoption of code-compliant rules, regulations, and legislation is considered as a critical requirement in the fight against doping in sport. If rules, regulations, or legislations is not in line with the code and international standards, WADA will issue a corrective action report. And if not addressed in the timelines as set out in the International Standard for Code Compliance by signatories, this may lead to a declaration of non-compliance, which can have serious consequences for sport in your country. For example, this may notably lead to the inability for your country to host major sporting events or even the exclusion of your country's athletes at the Olympic Games. To date, 18 national anti-doping organizations have been declared non-compliant for not having properly implemented the code in their legal system. Of these 18 cases, 9 were related to the rules not being in line, while the other 9 were related to the legislation not being in line with the code and international standards. Although the adoption of non-compliant rules, regulations, or legislation may lead to a declaration of non-compliance, the commencement of a compliance procedure for these reasons is a last resort measure. Above all, WADA seeks to actively collaborate and maintain a dialogue with signatories and stakeholders to ensure that any draft legislation is in line with the code and international standards before it is adopted and promulgated. However, in order for this to effectively occur, certain things must occur. First, WADA must be consulted on any draft rules and must be provided sufficient time to review and provide comments. It's also important to note here that there could be various rounds of review, feedback, and dialogue on any draft legislation. And it's important to take these different rounds of review into consideration. WADA must also confirm that the legislation is in line with the code and international standards before any adoption process begins. WADA must also be consulted, reconsulted, if any changes are made to legislation during the adoption process and before legislation is promulgated or comes into effect. I would like to pass the floor back now to Louis, who will discuss some things if you're thinking about adopting anti-doping related legislation.
Thank you, Jonathan. So after doing a careful analysis of your sport and anti-doping landscape, as well as an assessment of your legal framework, you have decided to proceed with adopting an anti-doping legislation. Given the importance of making sure that your anti-doping legislation is in line with the code, here are some steps that we would recommend you follow to ensure a smooth process free of any code compliance related problems. Step 1, get in touch with the relevant regional office of WADA to make us aware of your project and to establish a good, transparent channel of communication. Step 2, once you have developed a skeleton of your anti-doping legislation, in other words, what the legislation will contain, its table of contents, its structure, please send it to WADA's compliance unit so that we can already at this stage provide you with some feedback and guidance from a code compliance perspective. Step 3, send the draft anti-doping legislation to WADA's compliance unit for review in either English or French, which are WADA's official working languages. Please bear in mind that WADA may take up to 3 weeks to review and provide feedback on a document, and there is often a need for more than one round of review before a draft legislation can be considered as fully in line with the code by WADA. We therefore strongly encourage you to plan a sufficient amount of time in your agenda that will be dedicated to the review by WADA of the content of the draft legislation. Once we have reached the step of WADA declaring the draft legislation as fully in line with the code, you can then proceed with the formal adoption process. Please keep WADA informed throughout the legislative process, and as Jonathan mentioned before, should any changes be made to the draft legislation during the adoption process, it is very important that you provide these amendments to WADA so that WADA can review their compliance with the code and that any necessary modifications can still be introduced before the legislation is adopted. Finally, we invite you to share the key information you will have gathered from this presentation with the relevant stakeholders in your respective countries, such as your colleagues from the Ministry of Sport or the National Olympic Committee, so that all those potentially involved in the drafting and adoption of an anti-doping legislation are fully aware of what you have learned today. So before I pass the floor to Dr. Diego Grippo from the National Anti-Doping Commission of Argentina, who will present a case study of Argentina's legislation on anti-doping, here are some resources we suggest you look at on this topic. And first of all, you can consult the compliance section on WADA's website, which contains a dedicated section on anti-doping legislation. As previously mentioned, there is the guide for the operational independence of NADOs. There are a number of educational resources which are available, notably on the ADEL platform. And more generally speaking, do consult the code and international standards, as well as the guidelines to those international standards. And last but not least, the NADO model rules contain very valuable information to take into account before you proceed with drafting an anti-doping legislation. So without further ado, and thanking you all for your attention, I will now pass the floor to Dr. Diego Grippo.
Okay, thank you. Can you listen to me?
Yes.
Okay. So can you put the second slide, please? Okay. The main challenges of our NATO in Argentina. When we started working at the NATO in 2017, there was a lack of knowledge and understanding of the sport authorities, and I have to include here athletes and also support personnel, of the importance of having an anti-doping program in compliance with the World Anti-Doping Code. There was also a lack of interest from government authorities and commitment. At that moment, was very difficult for the NATO and for us and our team to make them understand the consequences of being in non-compliance with the World Anti-Doping Code. The Argentine law did not comply with the main provisions of the World Anti-Doping Code, so we explained that with the actual law, it's going to be impossible to comply with WADA. Basically, this law did not guarantee the NATO operational independence or the financial and administrative autonomy. There was also a lack of training staff and organizational structure required for anti-doping operational and technical areas. The NATO has a total staff at that moment of 7 people to cover operational and administrative areas. All these issues were exposed after the 2017 Code Compliance Questionnaire and the further audit. So, the key to success started with WADA audit in 2017 and the corrective action plan that created the first opportunity to modify the legal framework, the legal framework established in the previous law. In other words, we used the WADA corrective action plan in our favor to start with the most important changes of the law. The adoption of the law in 2018 created the National Anti-Doping Commission with the operational independence required by the World Anti-Doping Code and its financial and administrative autonomy. The National Anti-Doping Commission can receive funds from private sector, sponsors, act as a service provider, and also donations. The amendments of the legal framework and law was also an opportunity to involve the government and sports authority in anti-doping rules and policies. With their support, the law was voted unanimously by national deputies and senators at the parliament. So the new law gives the National Anti-Doping Commission the possibility to expand its organizational structure and to change or amend the law if it is necessary. The review and adoption of the 2021 World Anti-Doping Code was a new opportunity to improve and made amendments to operational provisions in our 2018 law. The problem was at that moment that we realized that to make that changes, we had to go through the parliament again, and that was very hard for us. So the lesson learned and advice is that WADA's audit and corrective actions could be the first step, an opportunity to create the legal framework when it's needed. In our case, the first important change introduced to the law was that the NATO authorities' mandates does not coincide with the central administration, with the government. So, if the government change, not necessarily means that the NATO authorities must change. The National Anti-Doping Commission's authority mandates are now by Olympic cycle, and also to ensure governance, the authorities of the board have deferred mandates so that the agency does not remain headless anytime. The second important change introduced to the law was that the executive government is now entitled to rule by decree by proposal of the National Anti-Doping Commission. So now, for future amendments of the World Anti-Doping Code are not required to go through the Parliament. So our advice and our suggestion is to highlight the convenience to start having a solid and strong legal framework, anti-doping law, to implement the national anti-doping programs. Thank you.
Perfect. Thank you very much, Dr. Grippo, and thank you again to Louis and Jonathan for the comprehensive presentation. Hello, everyone, again. Now we have a few minutes to have a Q&A session, which I hope will be very productive for everyone. As a reminder, you can present your questions either through the chat, the Teams chat, or you can send them by email to the compliance@wada-ama.org address. So we have received already by email a few questions. I will read the first one and answer it. The first one is, my country is drafting anti-doping legislation and defined terms in the code and international standards are reproduced in the legislation. Is this a recommended practice? So my understanding is that the question is about whether it is a good idea to incorporate in the legislation defined terms from the code and the international standards. So assuming that in the country there are also NADO rules, it is not recommended to incorporate in the legislation the definitions. Why? Because first of all, the definitions would already be part of the NADO rules. Therefore, incorporating them in the legislation would be a duplication. Secondly, the definitions traditionally are one area of the code that changes every time the code changes. This means that if the definitions are incorporated in the legislation in addition of being part to the NADO rules, every time the code change, you would have to change accordingly the legislation, which is something that we are trying to avoid. Because of this, it is not recommended to incorporate definitions in the legislation if you already have them in the NADO rules. So another question we received is, why is there a requirement for anti-doping legislation to be compliant with the code and the international standards, considering that governments and public authorities are not signatories to the code, and my country already adheres to the UNESCO International Convention Against Doping in Sport? So thank you very much. It's a very interesting and important question. So first of all, as part of WADA's mandate, we have to review the overall legal system that is used in the country to incorporate the code. In many countries, this will mean that we have to review the NADO rules, because the NADO rules is the only legal instrument used to incorporate the code in the legal system, the national legal system. However, where the country decides to use legislation as well to incorporate the code, then as part of WADA's mandate, we have to review that legislation as well and ensure that the legislation is compliant with the code. The fact that a certain country might have NADO rules that are in line with the code and does not represent a valid excuse for having legislation not in line with the code. Based on the principle of hierarchy of norms that I believe exists in every single country, the legislation always takes precedence over NATO rules. That means that in case of conflict between the non-compliant legislation and the compliant NATO rules, the legislation shall prevail. And this is clear an argument that could be used by athletes or athlete support personnel in court against the NATO if, for example, a certain anti-doping rule violation foreseen in the code is not considered as an anti-doping rule violation according to the legislation in the country, despite being an anti-doping rule violation in the NATO rules. This has been an approach that has been consistently followed by our independent compliance review committee and by our executive committee. This is an approach that there is a case law. As mentioned by Jonathan, there are already 9 cases of signatory NADOs, I should say, that have been declared non-compliant because of legislation not being in line with the code. So I think this question provides us with a very good opportunity to clarify that despite having NATO rules, legislation cannot be forgotten. On the contrary, it should always be updated when the code changes if need be. So another question is what happens if during the adoption process my government or public authorities make further changes to the draft legislation after WADA is deemed to be in line with the code? That's another very good question. So first of all, it is crucial that the final version of the legislation that is adopted and promulgated and enters into force is compliant with the code. In order to reach that goal, it is crucial that not only the draft that is presented to WADA before the beginning of the parliamentary procedure, but also the draft that comes out of the parliamentary procedure is fully in line with the code. Unfortunately, we have witnessed cases in the past where a country had created a draft law which was in line with the code, has subsequently started the parliamentary procedure. During the parliamentary procedure, certain edits were made without WADA even being aware. Those edits created a non-compliant situation because made certain articles non-compliant with the corresponding articles of the code. As a result, the legislation as adopted was non-compliant. And then it was very hard politically, but also in terms of timelines, to go back again to the parliament a few months later and ask the parliament to reform that legislation that they just adopted. So our strong advice here is to avoid, if possible, making changes to the draft once it has been declared by WADA as being fully in line with the code. If, nevertheless, changes are made during the parliamentary procedure, it is very important that WADA is consulted and there can be a dialogue with sufficient time allowed to ensure that the final draft is fully in line with the code. And this does not mean in any way to be any willingness from our part to interfere in the sovereignty of the country or in the parliamentary procedure. It is also meant to be a suggestion meant to work cooperatively to ensure that the end result is fully compliant. So I move to a few other questions. One that I see here in the chat is, besides the labeling of nutritional supplements as safe, what other activities have WADA observed NADOs participating in which are outside regular functions stipulated in the code? So here we have noticed that in some countries, in particular in Europe, NADOs act not only as a sport entity, if I may say so, but also as a public health institution in a way. As part of a public health institution, there are certain obligations that come along that belong more to Ministry of Health than to the NATO itself. When it comes to dealing with the general population and with the education of the general population, unless the NATO is very well resourced, it might be too much asking to the NATO to deal, for example, with education of the general population in terms of prohibited substances or in terms of supplements. The target would always be the athlete population, and then obviously there is a distinction between international, national, and recreational level athletes. However, if it goes beyond the recreational level athlete, this might be overwhelming for the NATO and might distract important resources from other activities that are more targeted on athletes. Another question that we received through the chat is how to regulate correctly financial autonomy for NADOs. It's a very important and interesting question. So first of all, we kindly refer you to the guide on operational independence that is published on WADA's website. That guide provides an important guidance as to what constitutes financial independence for a NATO, with very concrete and practical examples. The key principle, the same goal can be reached through different means. Again, it is not a one-fits-all approach here. We have to look at the diversity of each NATO, the complexity of each legal structure, and then by looking at this, identifying what's the best way to reach a certain goal. So in terms of the general principle, the key principle is that the NATO should receive its budget normally once per year, not on a weekly or monthly basis, in order to have a certain flexibility in terms of its activities. First, we can think of the case scenario where, based, for example, on information that the NATO has received through the intelligence department, additional testing is required in a certain month, additional testing that was not part of the test distribution plan for that month. The NATO, in order to implement an effective testing program, will need to conduct those tests. And in order to conduct those tests, will need additional resources. So if the NATO is only allocated limited resources on a weekly or monthly basis based on the test distribution plan, might not have those additional resources to make those additional tests. So it's very important that once the NATO is allocated, that budget has a certain flexibility in terms of how to use it during the year. Then, of course, being in most cases public money, so public funding, there will be certainly an obligation to report, probably at the end of the year on a biannual basis, how that money has been spent. But flexibility is key in order to ensure operational independence of the NATO. In my example, if the NATO had to ask for additional funds from the ministry, justifying those additional funds by saying we need to test those athletes on that day, then obviously it won't, first of all, the testing activity will not be no advance. Secondly, the NATO will have no operational independence in the development of its testing program. Another point that is important in terms of budget is ensuring that the NATO has the possibility to, while acting as service provider on behalf of other organizations, mostly other signatories, has the possibility to receive that extra funding and utilize it. This is commonly, it is a good way for the NATO of financing its activities. And we have seen cases where those extra funds did not go to the NATO, but went to a public entity, and then the NATO had to seek those funds from the public entity, but in order to do so, was obliged to ask what would be the destination of those funds and provide very, very detailed information. And again, it would be a breach of operational independence. So I'm just looking now at the chat to see if we have received other questions. Yes, I see here another one. is there any analytic review done to list or demonstrate areas of examples of where or how a country's legislation might typically verge towards a WADA non-compliance observation? Arising from that, has there been any tracking on one side where a country in its legislation has pinpointed any deficiencies or omissions in WADA Code of Rules? If so, how quickly WADA respond in making changes and improvement so that the best codes and standards are achieved for the good of us all? Thank you very much for this question. So, first of all, I would like to say that the reasons why legislation is non-compliant can be very different, depends from country to country. However, we have noticed some commonalities in a number of cases. Typically, one area where we have noticed a number of cases of non-compliance is the provisions corresponding to Article 2 of the Code. So Article 2 defines what constitutes an anti-doping rule violation. In Article 2 of the Code is traditionally reproduced verbatim as required by Article 23.2 of the Code in the NADO rules. So the countries in their NADO rules, NADOs, have already the full Article 2. However, a number of countries have elected to also reproduce the content of Article 2 in their legislation, even if they already had it in their NADO rules. Article 2, like the definitions, is another area of the code that changes every time the code changes. So we have seen cases of countries where the provisions in the law corresponding to Article 2 of the legislation were not in line anymore because they were based on a previous version of the code. Even if the country had the full Article 2 reproduced in the NADO rules, this obviously represents a serious nonconformity because, as mentioned before, of the principle of hierarchy of norms. In case of conflict, the legislation will always prevail. So if the legislation says that a certain conduct does not represent an anti-doping violation, and the NADO rules say otherwise, the legislation will prevail. Hence the importance of ensuring that legislation is fully up to date with the code. However, as mentioned before, our recommendation is to avoid duplications. So if Article 2 is already reproduced in the NADO rules, there is no need, in our view, to reproduce it also in the legislation. And avoiding duplications would also be very beneficial for the country because would put the country in a situation where the legislation does not have to be amended every time the code changes every 6 years, which we understand can be burdensome for a number of countries. In terms of WADA, we cannot prevent countries from adopting legislation that duplicates the content of the NADO rules, obviously. But what we have been trying to do consistently in the past years, and what we are doing also now through this webinar, is to make sure that we pass the message that we give best practice recommendation when drafting legislation so that certain issues can be prevented. When it comes to legislation, I think it's important to mention that at WADA, since many years ago, we keep providing individualized assistance to countries. So we understand that there is no one-fits-all approach. We understand the complexity of the task required for a certain country, and we keep providing individualized guidance, which means that we have regular discussions, virtual meetings, in-person meetings with stakeholders. We do our best efforts to ensure flexibility when reviewing the content of the legislation, taking into consideration the specificity of the legal tradition and legal structure in the country, legal terminology. We look at substance rather than the form when it comes to legislation. But at the same time, we also have, as part of our mandate, to ensure the end goal, which is compliance of the legislation with the code. So we received another question in the chat. What is the place anti-doping education in determining compliance and non-compliance with the code by signatory? This question particularly not only points to legislation, but also the structural composition of doping control system of signatory. So if it is about education, there is obviously a section in the code that is dedicated to education. That section is also reproduced in the model rules that we have created and made available to signatory to draft their own NADO rules. So we do encourage and recommend that an education section is dedicated in the NADO rules to this area. When it comes to legislation, practice can be different. In some laws, there are a number of provisions dedicated to education. In some other laws, there is no education section because everything is delegated to lower level legal instruments such as the NADO rules. So again, there is no one-fits-all approach. There is no obligation to incorporate education-related provisions into the legislation, but there is also no harm in doing so. Of course, it is always important to keep in mind that also the education-related article of the code can change when the code changes. So if it is the case, and if the previous formulation is no longer compliant with the code, then there will be a need to amend the legislation in order to adapt it to the new requirements in terms of education under the code. So I'm just looking now at both the compliance inbox and the chat. I don't see any other questions at this stage. As mentioned in the country, in the beginning, we do encourage all stakeholders, NADOs, public authorities, NOCs. Should you have any additional question, to please send it to our compliance email address. It will be our pleasure to respond to them by email. At the same time, to conclude this webinar, I would like to reiterate our strong willingness to provide as much as possible individualized guidance and assistance. We don't want to leave signatories alone in this complicated task. It is our goal to work cooperatively together. And as mentioned by my colleagues, the compliance procedure and the potential non-compliance is definitely the last resort. This is also the spirit of the international standard for code compliance by signatories. The goal is to work together toward a resolution of the matter, toward an adoption of legislation compliant with the code, avoiding any non-compliance. But while doing so, it is very important that everything starts with a self-assessment by the country, as mentioned, to determine whether there is indeed a need of legislation or not, and if so, what should be the scope of that legislation. So without further ado, I would like to thank very much again all the participants. I understand that in some parts of the world it is quite late, so thank you very much for being awake until this time and being with us. In other parts of the world it is very early, so thank you very much for waking up so early to attend this webinar. And thank you again, everyone, and have a good morning, afternoon, evening, depending on where you are in the world. Thank you.